Lawyer.
My lady, my lords, before I turn to Jenkins and Livesey, I'd just like to make a few short points arising out of my learned friend's submissions this morning. First point made was that the delay had not prejudiced but advantaged the husband. We would submit, in fact, that it's advantaged the wife and that he is disadvantaged. I will expand upon that later, but I'm going to return to that in my bullet points in a moment. At the outset, Mr. Hockman referred to this as being the husband's application. In fact, it may have been a slip of the tongue. It was the wife's application that initiated all of this. Sorry?
The way he put it was that it was the husband who raised as a preliminary point, whether the court had power to do what the wife had asked it to do.
Yes, but
Is that correct?
Yes, that's correct.
Yes.
But it wasn't his initiating application is the point I'm making.
Oh, we know that.
The next point is that the decision to direct a preliminary issue was a case management decision. It was not one devised or instigated by the husband. As at the time...
Well, you say it was not initiated by the husband?
No. The point
district judge...
Yes, decided he would deal with it in two tranches. As at the time of the consent order, it's been said that the wife was relying on family assistance. The point is made on the husband's behalf that neither he or his advisors knew about that. It's correct, the next point, that the husband was left with £41,000 of debts as a result of that order, which he was obliged to pay off. However, one debt that the wife was supposed to pay off was to Direct Line for £9,000. She didn't, and as it was in his name, he had to pay it. So the £50,000 figure was correct. An issue has been raised about the failure to contribute to school fees. This may seem a small point, but if I could just briefly take you to the consent order at page 145 PMS. This is what the issue is about. The husband gave an undertaking at 5.5 to continue to meet one half of the cost of the children's school trips and extras when they attend secondary school, to be agreed in advance in writing. The issue here was, in large part, that school trips and so forth were arranged, not in advance and not in writing. And so there's a dispute between the parties about that, which may seem a minimal point to raise, but the reason I raise it is that in answer to my Lord Wilson's question about the response to the offer we made to accept a measure, the response was, after making various preliminary points, to say that our client's proposal is that she would waive sums due from your client under paragraph 5.5 in the recitals to the order on the basis that your client will agree to the sale of the home being postponed until Tom completes his secondary education. So that was the substance of the response to the measure offer. The value of Formosa, my Lord Carnwath asked about the equity in that. Prior to this hearing, we sought to obtain an agreed valuation for Formosa for the purposes of the appeal, but that wasn't accepted. The wife's team say £600,000. The statement of facts and issues, which if I can just turn briefly to, at paragraph 13, says the second phrase, the parties agree that the value will have increased in line with residential property generally. That exercise we have tried to do using the house price index at e-glance for the southeast, using the Halifax house price index. Unfortunately, that only goes up to 2015, but the increase of 29.3% means that on a valuation of 525,000, as at 2010, the value now would be 678,663. This is all slightly unscientific, but if you look at Zoopla for Formosa, like the actual house, as of yesterday, the Zoopla figure was £766,000. Therefore, with 3% costs of sale of 22,980,
I was 700.
66,000. So with the costs of sale at 22,980 and the mortgage deducted, it would leave a net equity of 288,220, so that the equity would have increased by £235,266 in the period since 2010. Now, I accept that that is not definitive, but it gives a few indications of the likely increase in value. It's said that the wife didn't have an earning capacity. She didn't earn, but it's not accepted she didn't have an earning capacity. And the final point I'd like to make by way of update is that on the 8th of May of this year, Findlay Birch was born. He weighs 8 pounds and 13 ounces. Now, without more, I return to...
From which we infer that he's doing well.
Pardon?
From which we infer that he's doing well.
As his mother. I now want to turn back to where I was just before the short adjournment. And
On the facts, there is a statement from your client
yes,
in 2012 saying he was living with another lady,
yes,
and indeed in her house.
yes,
In paragraph 14 of the Statements of Facts and Issues, it says, in September 2016, H asserts that he commenced cohabiting with a new partner.
yes.
So that might be a second new partner, as it were.
Yes, I took instructions on that. Obviously, the statement was made in 2012, and he did live with a lady for about 2 to 2.5 years. They did plan to get married. The relationship lasted till about 2014. And whereas in our case, we've stated that he was paying rent at around £900 to £1,000 a month for the whole period, for the 2.5 years that he was living with this lady, he was making a contribution generally of about £400 a month.
That was in a home owned by her, was
Owned
it?
by her. And then when that relationship broke down, he went back into rented accommodation. He's remained in rented accommodation since, and he and his present partner are living in rented accommodation.
Thank you for clearing that up, Mr. Wilson.
Without more then, I will now go to Jenkins and Livesey at tab 17 and page 609, MS 609. My lord, my lady, I'm sure you're all familiar with the facts of this case, so I won't repeat them. But it did raise difficult questions of principle. And so those were dealt with by Lord Brandon. And at page MS 609, I want to begin just below the letter C, where he says, "My lords, there can be no doubt that this appeal raises important questions of principle in family law. None of the authorities which have any bearing on those questions are binding on your lordship's house. And I propose, therefore, to consider the questions first from the point of view of principle and to examine and comment on some of the relevant authorities later. In considering the questions from the point of view of principle, there are 4 matters which I think that it is necessary to state and emphasise from the beginning. The first matter is that the powers of a judge of the family division of the High Court or a judge of a divorce...
How much of this do you want us to read?
I just want to read down to the word diplock.
Well, perhaps we can do that.
Okay. My lady, I'm obliged. The key point is that the powers of a judge of the family courts derives from the statutes. That's where the power comes from. And the second point I want to take you to is in Dinch, which is in the first bundle at tab 14, MS 539. And my lady, it may be you'd want to read this as well. It begins about a third of the way up in the words Section 31 of the 1973 Act.
Yes.
And it goes through to the end of the quote by Lord Diplock in De La Sala at the top of MS 540.
Thank you. So shall we read those first?
Yes.
Thank you.
Right. The third point to make, which my learned friend has touched upon.
Your point is the once and for all point, isn't it?
Yes, it's the once and for all point.
But I mean, unless one can bring oneself in Section 31, one's back on those principles, is
Yes.
the point,
Yes.
and which are much more restrictive from Section 31.
Yes. The third point is that it is plain.
I mean, it's important is because the case against you seems to be that even if this isn't strictly within Section 31, nonetheless we should sort of treat it as analogous in some way.
Yes.
And you're saying that's wrong, I suppose.
That's wrong.
I see. Well,
The court's powers come from the statute.
Yeah.
And the third point I make is that it is plain that Sections 24A and 31.2f were introduced following recommendations of the Law Commission report, Lawcom number 99, Orders for the Sale of Property under the Matrimonial Causes Act. And I'm sorry to jump bundles, but there is, and it's been touched upon, I think, the exposition of this by Lord Justice Thorpe in Amelan, tab 22 at MS 726. And this is cited by my learned friend, but it's worth repeating. In my judgment, that part of an ancillary...
page 7.
726, 726. In my judgment, that part of an ancillary relief order that orders sale must be taken since 1st of October 1981 to be made pursuant to Section 24A, as the 1980 Law Commission report makes plain, there was a general perception that the statute required an express power to order sale to settle uncertainty as to whether such a power existed, and to avoid the artificiality of resort to the Married Women's Property Act 1882 in search of such an ancillary power. Thus properly construed, the order of 12th February 1990 constituted a variation of settlement order under Section 24(1)(c) and D, to which was attached an ancillary order under Section 24A. I think that the point that I think Mr. Scott was making, Mr. Blair, sorry, was making, was that you can't have an ancillary order like that because you can't bring into play Section 31.2f for a settlement of property order. What the court was saying was, it's there, so you can't undo it. It's there. There's an order of sale there. But your second point, that it's to vary it would invade the primary territory of the territory of the primary order, is a good one. And it was for that reason that in Dinch and Dinch there was a Section 17 application linked in, which created some of the problems, particularly with the drafting of that order. So the Section 31 and Section 24A are in the first bundle, and I want to turn to them very briefly, if I may. Section 24A is at tab 3. I think it is. And it reads, at subsection 1, where the court makes an order under sections 23 or 24, then on making that order, or at any time thereafter, the court may make a further order for the sale of such property as may be specified in the order. So section 24A gives the court the power to make a subsidiary order for sale. And then section 31, subsection 1, which is at tab 6, says where the court has made an order to which this section applies, then subject to the provisions of this section, the court shall have power to vary or discharge the order. So subsection 2F allows the variation or discharge of an order made under section 24A1 for the sale of a property. And it's our submission that in this case there simply is not an order, and as the court's powers are derived from the statute, there can be no way in which it could be possible for that to be enacted or engaged. And that was the view taken by Lord Justice Macomb in the case in point. Can I take you to the core volume, pages 135 and 136, where paragraphs 32 and 33, in the end, applying these considerations, the court's decision in Milan, which is while binding upon us, is obviously distinguishable on its facts. The question for me was whether this proposed variation was the equivalent of a section 24A order at all. If it was, did it revisit the territory of post-divorce capital adjustments incorporated in a final order, and the territory of the final order under section 24 so as to fall outside the jurisdiction under section 31? Or was it merely in the territory of an ancillary order under section 24A? If it was not the equivalent of an order under section 24A, would there be jurisdiction which might sensibly exercise to vary this undertaking as now sought? And then paragraph 33, as already indicated in my judgment, this is not a case involving an ancillary order under section 24A of the Act at all. Indeed, as a matter of form, the undertakings are not such orders, though it was convenient for Mr. Hockman in his attractive but perhaps deceptively simple argument so to submit. I do not accept, as I've said, that these undertakings are to be regarded as merely incorporated by way of undertaking something that the court would or could have ordered under section 24A. Clearly, paragraph 4.3 could not have been so ordered with paragraph 4.4 as the fallback. If the wife could not achieve the objective of paragraph 4.3, in my judgment, the undertaking paragraph 4.4 is not therefore an undertaking equivalent to a section 24A order. And the other point is...
Well, I thought you disagreed with paragraph 34, Mr. Wilson.
I do.
Oh, right.
I do. I should have mentioned that in our case statement. We do say that we don't think that he was so subscribed, or the court was so subscribed. The court could have ordered an order for sale at first instance, as the judge.
First point is there is no order. But your second concession is this undertaking here could have been framed as an order.
It could have been framed as an order.
Yes, very well.
And that would have been an order under section 24A?
Yes. But it wouldn't be capable of variation, we say, because it would be invading the primary territory of the main order.
Well, that's a separate point.
Yes.
That's the onward
yes,
point.
that's the onward point. The fact
But I mean,
is...
the jurisdiction point, whether we get into section 31 at all, it simply depends on the fact that this was done by undertaking rather than by order. Does that make sense?
Yes, it does.
I mean, when I read what Lord Justice Macomb said, it seemed I understood that. Now you're saying he's wrong, and that really it's all a matter of form, which is less attractive.
No, it could have been dealt with by way of an order, but it wasn't.
Yeah.
And the statute provides for the variation of orders, not quasi-orders or things that are analogous to orders.
And so, I mean, I suppose you could say the legislature was perfectly aware that there were differences between undertakings and orders and chose not to extend it to undertakings.
But it goes further than that in any event, because even...
You never really vary an undertaking anyway, do you? You discharge it and accept another one.
Well,
Indeed, you can discharge it on terms that you will only discharge it if another one is offered.
well, my Lord, yes, and we deal with that point when I started my submissions, our case rather, with Cutler and Wandsworth Stadium in answer to your Lordship's question, because it's a very good point, and that's the way we understand it. And in fact, when one looks at some parts of the decision in the Court of Appeal here, they actually do talk, or Lord Justice McComb does talk about varying undertakings, which doesn't work. It's not an appropriate use of language. It's probably slightly sloppy use of language, but the proper course is to use the language used in Cutler. And indeed, when one looks at the Mid-Suffolk case, and one looks at the Kensington Housing Trust case, the same loose language is used in those cases as well. But
So the correct formulation, sorry to just interrupt, is that the court has jurisdiction to discharge the undertaking and to do so on terms that another undertaking is raised. But you say that the criteria in Section 31 have nothing to do with that. Is that right?
yes.
And so the difference between you is whether one can sort of import the Section 31 criteria as, in a sense, elements of the discretion of the court when deciding whether to discharge the undertaking on terms.
Yes.
All right.
But in any event, it's not, even if that undertaking was in the form of an order, in my submission, it would not qualify in terms of being for the purposes of the implementation or enforcement of the primary order. And we dealt with that in our submissions. It's a point that is accepted by Lord Justice McComb. Before we leave that, we look to his paragraph 28 at MS 135. Where he says, my view is that the undertakings in this case do not aid the enforcement, implementation or procedure of the primary order for the transfer of the property to the wife in any respect. The property transfer order as a matter of construction, enforcement and implementation is independent of and separate from the undertaking for ultimate sale. The transfer order could be enforced and implemented even if, as a matter of practicality, the transfer would have to be subject to the mortgage without recourse to the undertakings, which would remain live, whether the Section 24 order had been implemented or not. And we attempted to deal with that point in our submissions at paragraphs 21 and 22 of our case. Which is at MS 104, where we say that the undertaking at paragraph 4.4 does not aid the enforcement or implementation of, or the procedure in respect of the primary order, that the respondent transfer his beneficial interest in the matrimonial home to the appellant. It stands alone. It's stretching language, even if one can get over the fact that this is an undertaking and not an order, to say that the undertaking falls within that procedural mechanism for implementation and enforcement. That the proposition in paragraph 22 is accurate can be gleaned from a consideration of the terms of the order. Clause 1 required the respondent to transfer all his legal estate and beneficial interest in the home to the appellant within 28 days from the date of decree absolute. Decree absolute was pronounced on the 14th of October 2010, so that the obligation to transfer the legal estate and beneficial interest in the former matrimonial home crystallised on about the 11th of November 2010, whereas the appellant's obligations under the undertaking did not take effect until almost 2 years later. Can it be said, therefore, that the undertaking aided the enforcement or implementation of the order as it stood? So we say in any event it doesn't fall within section 31(2)(f). And in those circumstances, we say that one, if that is right, one does not get to section 31(7) and the broad panoply of factors that my learned friend prays in aid, and in particular the first interests of the children. However, that is not to say that the first interests of the children were not the first consideration when the order was made. That can be clear from looking at some parts of the attendance note in relation to what happened during the negotiations on the day, which can be found at page 182, is where it starts. And I'll be coming back to this point, but what is clear when one reads this attendance note, and it needs to be considered quite carefully, is that it was plain that the judge felt that this house needed to be sold straight away, that it couldn't be afforded, and the family was heading for disaster financially on the sheer unaffordability of it all. And it was simply not tenable for them to carry on. And if one looks at page 187, there is a passage that begins, DJ Cross said, "Is this going to matter?" And I would recommend that it be read in its entirety at some point, but for the moment I want to start about 8 lines up from the bottom. He says, "I should make my feelings quite clear, to use a phrase, they're living fantasy land, unreality land. This entire family should be clinging to the same life raft, which is a place to live that is afforded, taking in lodgers if necessary, or the whole family should be in rented, in which case we need to know what's available and how much it will cost. The parties need to spend less time looking at where the money went and stop looking back down the track. Instead, look forward and see the very large train coming towards them with ruin written on the front of it. So if they cannot get their heads together and avoid running into that train with ruin written on it, they need to think how much money they've got and haven't got. And don't spend."
Mr. Wilson, speaking for myself, I've never come across a case where it has been correct to interpret the order, the substance of the order, if you like the word territory, the primary territory, as opposed to the secondary territory, by what judges say en passant, or what husbands tell their counsel, or what wives tell their counsel. I'm very surprised.
My Lord, the point that I'm making is, if one goes back a page to page 185 at the top, second paragraph down, there was a long discussion between counsel, which begins with the words, "We then had a long discussion," and it centred around the fact that Tom would finish year 6 in 2012. And so that the reason for the postponement of the sale, notwithstanding it being the husband's case, that it was not affordable, was to take into account the interests of the children. And at page 248, which is the husband's statement, he explains his thinking as to why he agreed that, and I can leave that to be read. Significance, my Lord, was that the bargain that he struck was for the benefit of the children, when, if that bargain hadn't been offered, he would have simply gone for an order for sale. And here we are, having struck that particular bargain many years later. So the point I'm making is that the intention was to represent the interests of the children and take their interests into account at the outset when this was done. And it's perhaps useful to look briefly at another exchange of correspondence at page 215. When the court received the consent order for sealing, a letter was written back to the wife's solicitors. We didn't know about this until a lot later, asking in particular at paragraph 3, what about the position of the young children? And there was a letter back by return, and I only take you to point 3. As regards the issue of a clean break, as the district judge can imagine, this caused a significant amount of negotiation and discussion. Mrs. Birch herself volunteered the clean break to secure the husband's agreement to the maintenance of the home and children's school fees. Because of the mortgage interest relief arrangement, it's clearly beneficial for her to remain in the home as long as possible until shortly prior to the final separation. Mrs. Birch worked in relatively higher paid employment, and it's her hope within the next couple of years or so she will be in employment generating a salary of 30 to 40,000 per annum, as she had done previously, while there will obviously be childcare costs associated with this, bearing in mind Mr. Birch's agreement not to force the sale of the home to take on 60% of a significant level of debt and remain tied to the mortgage account for at least another 2 years. Mrs. Birch felt it was appropriate to volunteer the clean break. The court may rest assured Mrs. Birch has been significantly and extensively advised as to issues and affordability, but she remains resolute in her determination to remain in the home and for the children to be privately educated during their primary education at the very least. And a copy of that letter, page 218, was sent to Mrs. Birch on the day it was sent to the court. My Lord, but before leaving the question of the interests of the children, the case as painted by my learned friend is that it's very bleak indeed. That must, to some extent, depend upon where the true answer lies as to the value of the property. Because if the property has got an equity in the region of 288,000, even with the deduction of the legal aid costs, she has a healthy, or would have a healthy amount of money, which would allow her to rent, certainly in the vicinity of the schools, if that is what she wanted during that time. The question of invading the territory of the primary order, that is obviously Lord Justice Thorpe's shorthand for it, but it is a word he uses, in fact, in Kensington Housing, where he talks about not being able to invade the territory of the primary dispute, so he uses it in other contexts. But basically what he's saying is that what you can't do is vary a final property order. That's what it amounts to. And certainly the judges below, when looking at this, were very firmly of the conclusion that that is exactly what it did. And they, of course, had the benefit of hearing the case in some great detail. And the...
You mean to say we don't?
No, I didn't mean it in that way, my lady. I didn't mean it in that way. The paragraph I wanted to take you to is paragraph 42 of his judgment at page 158. Where he says, the change in the order which Mrs. Birch seeks is a substantial one. She seeks not simply a postponement to allow further time to secure Mr. Birch's release, but a change which would mean that the property would not have to be sold until Thomas reaches the age of 18 years. That was never part of the original proposal. There is nothing in the order to suggest that the age of either of the children was to be a consideration in determining the date of sale. And so if this had been expressed as an order for sale, in my judgment, a variation would have been precluded by the case of Amelan. As I say, that much was accepted at any rate before the district judge. And when the district judge looked at it, he said at page 167, thus, paragraph 16, thus it seems to me that Mrs. Birch's application to vary the undertaking, to postpone Mr. Birch's release from the mortgage or the property being sold in default until Thomas has reached the age of 18 or until both children have completed full-time education, is in effect an attempt to turn the consent order from what it is into a rather different property adjustment order. It would become more like a measure order to preserve the property as a home for the children until the latest to occur of those events, and the property then would be sold, with Mrs. Birch receiving all of the net proceeds. Or if she would be able to, at that stage, to obtain consent to the mortgagee to release Mr. Birch to retain the property. That would have been a capital settlement that the parties might have agreed on the 1st of March 2010, but I consider that an objective consideration of the terms of the consent order, what they agreed was substantially different. That was for the property to be transferred to Mrs. Birch within 28 days of decree absolute, and Mr. Birch to be released from mortgage liability as soon as possible, in any event by no later than 30th of September 2012, with respect to which Mrs. Birch undertook to sell the property to redeem the mortgage if unable to obtain consent of the mortgagee and to release him from the mortgage liability. So that's the ways in which it's been described by them as being, as for want of a better word, invading the primary territory. Going back, if I may, to part of what His Honour Judge Waller had to say at the conclusion of his judgment, paragraph 61, page 161, where these arguments were put before him. He says at the bottom 6 or 7 lines, in a general sense, one might conclude that it would be in the interests of the children for the property not to be sold at the moment, since the sale might leave them in difficulties in relation to housing. And that, of course, is of great concern. However, the court's powers, even on Miss Campbell's arguments, are to consider the interests of justice. While the children's welfare, of course, plays a significant part in that, one has to think about the background to the original order, or at least the way in which the order was framed. The parties entered into it as it happened voluntarily, an arrangement recorded in the undertakings and order which provided for a mechanism by which the property could be transferred to Mrs. Birch, and by which Mr. Birch's position could be protected through his release from his covenants under the mortgage. In my judgment, it is impossible to separate out different parts of the order and to say that some of those, or part of those, should be changed or delayed and parts should not. And that was very much the view of Lord Justice McComb, we say correctly, when he was looking at this. Bear with me while I find it. He talks, and I can't find the precise passage immediately, about the proposed variation, changing the substratum of the order. 41. Page 138, I'm obliged. Paragraph 41. If contrary to the view that I've expressed, I'd have thought the undertaking in paragraph 4.4 was the equivalent of an order under section 24A, I would still have taken the view that the variation sought would revisit the territory of the primary order under section 24. I reached this conclusion for much the same reason as stated in paragraph 39 above. The proposed variation in the context of an application to vary an ordinary undertaking. The variation seeks to undermine the substratum of the final order. In my view, it would be artificial to say that a variation of the undertaking would leave the terms of the property transfer order unaffected, and therefore all that was affected was the undertaking alone. And I'm going to
Where does Lord Justice McComb address what precisely has been the effect on the husband of failing to be released as a co-mortgagor?
I'm not sure he does, my lord. Bear in mind we were dealing with the preliminary issue.
But he's talking about the substratum of the final order.
Yes.
And if you're looking for the substratum, it might be helpful to see what, because of the wife's failure, has been the result for the husband.
Would you bear with me a moment, my lord? I don't think it's in there, my lord.
And when a judge learns that somebody who's supposed to be released from a mortgage hasn't been, I suppose the judge's first question would be, well, how much has he had to pay as a result of not being released under the mortgage? Where does Lord Justice Macomb deal with that, Mr. Wilson?
I don't believe he does, my lord. But, my lord, the point is that, and I'm going to return to this later, if one looks at paragraph 30, where he's dealing with undertakings, where, after quoting Livesey and Jenkins, he describes the undertakings are as an essential part of the bricks and mortar with which the edifice of such financial orders are constructed. So and the substratum in this case, the foundation of it, the thing that made a deal happen, were the undertakings. And what is effectively being proposed is that the whole edifice of the consent order be shifted 6 years down the road, and that would never have been agreed to. My lord, just dealing with the question of prejudice, I said I returned to that question of prejudice in my submissions, but I'll come back to it now. You probably recall it from the case. I deal with it at paragraph 31, where, answering my learned friend's comments in their case about effectively Mr. Birch having a form of proper adjustment of order, saying that's simplistic and wrong in the real world, the order intended that he be released from the liability in the eyes of the outside world by September 2012. Notwithstanding that indemnity is being given until such time as he's released from the liability in the eyes of third parties, in particular potential mortgagees, he's unable to make use in any way of the intended consequences of that indemnity and these undertakings. In particular, the value of the appellant's equity will continue to rise with property prices, whilst the value of the indemnity to the respondent will remain static.
Yes, we have read all this. Basically, it's the impact upon his ability to borrow elsewhere, isn't it?
Borrow, get back onto the housing market. If the property had been sold when it should have been sold, and obviously we don't know the true valuation of Formosa, he would have been able to build some equity, and he has lost that opportunity to build some equity. And you've obviously read his witness statement where he tells you what his financial circumstances are, so I won't repeat that. But I say, or we say very clearly, that the nature of the order is substantially changed if these variations are allowed. I've already made the point that we say it falls outside of Section 31, so one's really left then to turn to questions of the undertakings. And there is an overlap between these, and I've already mentioned it. And it may be the easiest thing to do is just to take up our case in the bundle and, to save time, simply see the quote on page 97, our page 3, from Cutler.
Well, that's the terminological point that we queried when we gave permission, and it's now agreed. So the terminology has been wrong, but that's only terminology.
Yes.
So my vote, that's a very useful quote from Cutler. Well done for finding it,
Thank you
Mr.
very
Wilson. But I think we've got to move on from that.
Of course. The point I was going to make after that, which again I don't need to take you to documents for, is that I've already touched on it. When Lord Justice McComb was talking at paragraphs 39 and 44 of his judgment about varying undertakings, that is loose terminology, really, because the court can't have the power to rewrite the terms of a promise given by a party to the court, as opposed to deciding to release him from it and taking an alternative undertaking. And it's again a familiar quotation from Jenkins and Livesey at tab 17, page 618, towards the conclusion of that case. Page 618 at the bottom there, beginning the third matter, and I may leave you to read that, my lord and lady. Of course, it ends with the well-known quote that such undertakings are enforceable as effectively as orders. I want to revisit some cases that my learned friend referred to. In particular, I want to revisit the Kensington case to get a flavour of it. And briefly, the facts of this case were that Kensington Housing Trust had a tenant by the name of Oliver who kept on flooding her apartment. And so they took out injunctions against her. She promised not to do it, and then it happened again. And then they would take her to court again, and she promises not to do it, and they give mutual undertakings. If she doesn't cause or permit a nuisance or annoyance to any of her neighbours, or cause or permit, this is page 545, any flood of water in or from the premises known as 14D Hedgegate Court, the appellant would undertake to find her suitable ground floor accommodation somewhere else. Well, the Housing Trust found a place that wasn't suitable and then found a place that was suitable, but in the meantime, the flooding had carried on. And so the Housing Trust decided that they didn't think this was fair, that they shouldn't be held to their undertaking when she was blatantly ignoring her own undertaking. And that was the context in which it went to court. The first instance judge, or it was a recorder, I think, Mr. Dean, concluded that all the merits were on the side of the Housing Trust, but he didn't think he had the jurisdiction to release them from the undertaking. So it was in those circumstances where there were all the merits on the side of the Housing Trust that the matter went to the Court of Appeal, and the court came to the conclusions that it did. It was an undertaking given which they couldn't have been obliged to give, but the defendant could have been ordered to give the undertaking she gave. They went beyond the call, and then ultimately they gave up and wanted to be released from their undertaking. So, first of all, it's a very different case from the one we have. And secondly, it was one where the justice and the merits were so far one way that it was almost inevitable that the Court of Appeal would come to the conclusion that they did. But it has to be seen that that context, rather, has to be understood when one's looking at the decision that they made, because it is quite clear that this was an unusual case in which there were reciprocal undertakings and one party simply wasn't obeying them. And It's interesting to see, and the case repays rereading for that reason, the fact that Lord Justice Judge does quote Russell and Russell, having just talked about principle, where Lord Justice Jenkins said, "It is always competent to the court to discharge an undertaking given to it if in its discretion the court comes to the conclusion that that is the proper course in the interests of justice." But the important point, which my Lord Carnworth picked up, in order to obtain a discharge of the undertaking, he would have to show a real case of hardship, some essential change in his circumstances, for after all he did voluntarily give this undertaking to the court. When it suited him to do so, if he could make out a sufficiently strong case, it would be open to him to apply, and it would be open to the court, if satisfied with the case he made out, to discharge the undertaking. So that was cited with approval in that case, and in my submission, taken with the fact that the background facts of that case are very unusual, it doesn't, in my submission, bear the weight that my learned friend would seek to put on it. The Mid-Suffolk case I want to revisit as well, because what needs to be understood about the background to this case was it was another case of a man repeatedly breaching injunctions. He gave an indefinite undertaking not to do it again, and it came up before a different judge with allegations of contempt of court. And if one can take it up, if one turns to page 621 in tab 18, the words beginning, "In January 2005, a different judge, having heard the restored committal proceedings, imposed fines in respect of the defendant's admitted breaches, and then raised of his own motion concerns about the terms of the 1999 undertaking, in particular about the fact that it was not limited in time. Following further argument, in April 2005, he decided he had jurisdiction to modify the undertaking by way of releasing the defendant from aspects of it, and that it would be just to do so. He deleted the words "or otherwise howsoever" as being too imprecise, and added nothing to the undertaking while causing unnecessary complications. The words "or otherwise howsoever" as it being too imprecise, and adding nothing to the undertaking while causing unnecessary complication. And he decided that in view of the circumstances having changed by virtue of the passage of time, and in view of the commencement of planning proceedings, the eventual outcome of which would and should supersede the undertaking as regards nuisance, he should limit the undertaking in time so as to expire on the 1st of April 2007, thereby allowing time for the planning proceedings to be brought to a conclusion. Allowing the appeal, that although the court had jurisdiction to vary or discharge an undertaking given to the court, if it was just to do so, such a decision could only be justified by a significant change of circumstances, that although in certain types of case it might be appropriate to impose a time limit on an injunction or undertaking, given the lengthy history of the matter and the repeated breaches of the undertaking, the mere passage of time did not of itself justify releasing the defendant from his undertaking. The question of nuisance was independent from whether the defendant complied with his obligations under planning control, and so on. And then per Buxton LJ on page 622, the jurisdiction to vary or discharge an undertaking has to be considered against the background of three undoubted principles. One, at least when given as an alternative to a final injunction, an undertaking is equivalent to and of the same effect as an injunction. Two, once sealed, an order of the court can only be displaced by appeal. Three, just as an injunction once issued is an obligation to the court, obedience to which is not under the control of the opposite party. So an undertaking given to the court, not to the opposite party. Those principles would seem to militate strongly against the disturbance of the terms of the undertaking otherwise than on appeal. And the most important judgment really is that of Lord Justice Buxton, which is at page 637. And he sets out those principles on that page. And then he then deals on page 638 with the Kensington Housing Trust. I don't read all of it, but halfway down, he makes the point that there was a strong element of reciprocity in Kensington Housing Trust that is absent from our case. All that said, however, it is fairly clear that this court did envisage the setting aside and thus the alteration of any undertaking, final or not, in appropriate circumstances. What therefore needs careful scrutiny is the basis on which the jurisdiction can be exercised. Two bases were suggested to the judge and to us. One, that the alteration or discharge was the appropriate course to take in the interest of justice, this being the way in which the ratio of Kensington Housing Trust is expressed in the head note. And two, if there has been a material change of circumstances. As to the first of these, while it is no doubt a necessary condition that an order under this jurisdiction, as under any jurisdiction, should be just, I cannot accept that it is a sufficient condition, and cannot accept that this court in Kensington Housing Trust intended so to hold. The judge's view that he was entitled to do justice without further qualification led him into error in three ways. First, he seems at his paragraph 7 to have been influenced by the fact that when the undertaking was given, Mr. Clark had dispensed with his legal advisers. That might on appeal be a ground for saying that consent had not been full or properly informed, but it cannot be a reason for the alteration of the order or by a court of concurrent jurisdiction. Secondly, the judge thought the original order was demonstrably too draconian, and the term or otherwise, howsoever, should not have been included. In both of these respects, the judge impermissibly converted himself into an appellate court. There was no basis for that step apart from his belief that it was open to him critically to review the justice of another judge's order. Then paragraph 56, this jurisdiction should therefore be limited to significant change of circumstances. Some guide to the necessary extent of the changes provided by Lady Justice Butler Sloss in Kensington Housing Trust, where she suggested that developments must have occurred which made it no longer proper to punish the undertaker for breach of his undertaking. It need hardly be said that this requirement is unlikely to be satisfied if, as happened in this case, the contemnor is in one and the same proceedings, punished for contempt by breach of the undertaking and also relieved of future liability under the undertaking. And quite apart from that, for the reasons given by my Lord Justice Lloyd, the stringent standards, I'll say that again, the stringent standards required to alter an undertaking given in lieu of a final injunction was plainly not met in this case. So they're saying that the standards are stringent to change and they have to be significant in the nature of the change.
Yes, you say the more important judgment is that of Lord Justice Buxton. Of course, Lord Justice Gage agreed both with Lord Justice Buxton and with Lord Justice Lloyd. Lord Justice Lloyd gave the first judgment, and without going into it in detail, if we turn quickly back to 628, 629, we see him quoting the Kensington Housing Trust extensively, and then saying at paragraph 20 on page 629, it's accepted by both parties the judge had jurisdiction to discharge or modify the undertaking, discretionary power on his part, discretion to be exercised in accordance with the guidance given in the case that I've cited. So that's his approach with which Lord Justice Gage agreed.
Yes. What's the effect of paragraph 17?
Yes. I agree with Lord Justice Buxton that this is a necessary but not sufficient condition for the exercise of the jurisdiction. I don't think that they were necessarily in disagreement on this. There is... Well,
Lord Justice Gage clearly thought they weren't.
Oh, possibly. No, he says, for the reasons given by both Lord Justice Buxton and Lord Justice...
Well, that was the point. I mean, he clearly...
I see.
He clearly thought
you start from the assumption that they were thought to be in agreement with each other, and you're entitled to make that submission.
Well, he probably agrees with a bit of both of them, perhaps, but one doesn't know.
Well, no, one normally does read both judgments before one says one agrees with both of them. But there we are.
And it wasn't an extemporary judgment, which is what I was just checking.
No.
Taking things slightly out of turn, I think it's... Well, I'm not sure it's necessarily out of turn, but I think there are parts of L&L that I think I would like to refer your lordship's ladyship to, that my lady friend didn't take you to. And a lot of it is to do with bad legal advice. but I would wish to take you to paragraph 60. My learned friend referred to paragraph 67, but I think there's some useful dicta prior to that. He said there was more.
Page.
Sorry, MS 577, sorry. And this is where two threads come together. Some of this, I think, was... There was more sustained argument, however, as to the precise ambit of the court's jurisdiction, A, to release or modify an undertaking, and B, to decline to enforce an order that remains executory. I shall deal with them in turn. The jurisdiction of the court to release or modify an undertaking, and the basis upon which the court can do so, was considered very recently by the Court of Appeal in Mid-Suffolk District Council and Clerk. The court was pressed with its earlier decision in Kensington Housing Trust and Oliver as authority for the proposition that an undertaking can be released or modified by the court if it is just to do so, or as it was put by Lord Justice Jenkins in Russell and Russell, whenever it appears to the court that circumstances have arisen which make that course a proper one, in the interest of justice. That argument was rejected. Lloyd and Buxton LJJ, with whom Gage LJ agreed, both said that although that was unnecessary, it was not a sufficient condition for the exercise of the jurisdiction. Absent some other ground upon which an appellate court can properly interfere, the court can modify or release an undertaking contained in a final order only, one, if it is just to do so, and two, there has been a significant change of circumstances. See per Lloyd LJ at paragraph 17 and 47. Buxton LJ summarised the position at paragraphs 55 to 56. And
Is this adding anything to what we've already read several times?
That sets out his view, but if I can just say, without going into it in detail, the position of Lord Justice Mumby was to favour the approach in Mid-Suffolk over the other approach. So then I want to go to paragraph 67, which my learned friend read some of. It's dealing with executory orders. Merely because an order is still executory, the court does not have any more than it has in relation to an undertaking any general and unfettered power to adjust a final order, let alone a final consent order, merely because it thinks it's just to do so. The essence of the jurisdiction is that it's just to do so. It would be inequitable not to do so because of, or in the light of some significant change in the circumstances since the order was made. Whether it is enough that there should have been a significant change of circumstances to adopt the phrase used by Lord Justice Buxton in Mid-Suffolk, or whether, as Mrs. Justice Bracewell seemed to have assumed in Benson and Benson, it is necessary to meet the more stringent test in Barda and Kalawori, namely that there has been a new event since the making of the order which invalidates the basis or fundamental assumption upon which the order was made, is a refinement which there is no need for me to explore here. So Mr. Justice Mumby saw the competing strands as being either the Mid-Suffolk test or the Barda test. I don't take you to the case of Benson. It's in the papers, in the authorities. Briefly, in that case, a consent order was made in, I think, December 1992, and the wife was declared terminally ill in January 1993 and died in June 1993. There was a variation by agreement in July 1993, and then the husband said his businesses were going down the pan and tried to reopen it again. And basically, Mr. Justice Bracewell looked at that whole scenario in terms of Barda and concluded that because of the delay before lifting making the application, and because his business problems existed before the original order, he failed the Barda criteria. And my lords, my lady, I'm sure you're all familiar with the Barda criteria. I could take you to that judgment, but I'm sure everyone's very familiar with what was said there. And so the way in which matters there rest is, so far as Mr. Justice Mumby was concerned, those are the two alternatives that were available when it came to dealing with executory orders and I think as well undertakings. And
But, paragraph 113 of Justice Mumby's judgment deals with section 31,
yes,
which he says is quite different and there's no change of circumstances requirement. But he's not there dealing with Ormelian, he's dealing with the thing in general.
the facts of this case are very strange.
Yes.
The
I don't mind about the facts. Are you saying that section 113, which was read to us by Hockman, doesn't really have anything to do with this case?
Doesn't have anything to do with this case. What happened in this case was the husband gave an undertaking to pay his wife significant maintenance even after she remarried. And then he regretted it. Yeah. And he tried to get the orders varied. He failed on everything apart from the section 31 point where Mr. Justice Mumby said there is clearly a jurisdiction under section 31 to vary that periodical payments order. So it was dealing with the periodical payments element of it. Sure. May I then go back to Mr. Justice McComb in the case on appeal. Paragraph 38, page MS 137. He is citing from Mr. Justice Mumby in L&L, and at paragraph 38, he sets out what I've just read to you, and the comment that Mr. Justice Mumby didn't feel the need to explore the refinement between Benson or Barder and Mid-Suffolk. I don't need to explore that refinement here. And then Mr. Justice McComb says, unlike in L&L, however, in the present case, it seems to me that it is necessary to explore the refinement. The undertakings now sought to be varied were part and parcel of a comprehensive consent order resolving the parties' financial affairs on divorce, without which the other orders, including the substantive transfer of property order, would not have been made. Without the various undertakings, there would have been no property transfer order at all. The variation now proposed would undermine the substratum of the final order made with the consent of the parties and the approval of the court. In my mind, judgment is just that type of variation against which the highest courts have set their faces in cases such as Dinch, to which I have referred. Unless, as Mumby said, the new event invalidates the basis or fundamental assumption upon which the order was made. However, it seems to me as clear as Mumby J. said, the jurisdiction to vary the undertakings must technically exist, even if it's ready to be exercised. This may particularly be so in family proceedings when agreed financial arrangements derive their effect from the order itself, as approved by the court, and not from the underlying agreement between the parties. And so he, in my submission, in that passage, adopts the Barder approach. It's a question of invalidating the basis of fundamental assumptions upon which the order was made, or undermining the substratum of the final order. In my submission, that is closer to Barder than it is to Mid-Suffolk. And it's our submission to the court that the Barder approach is the appropriate one, particularly when one is dealing with final orders.
But the Barder approach was being applied to an order which was not capable of variation. The whole point about it.
I beg your pardon? Yes.
The Barder approach was being applied to an order, in effect, to set aside an order which was not capable of variation.
In the Barder case itself?
In the Barder case itself, yes.
Yes.
And that is why it's only basically if something has happened which frustrates the original order. Now, we're not talking about that here. We're talking about something slightly different, or in fact, quite considerably different.
Well, my lady, what we say is that Lord Justice McComb seems to have taken that approach to it, and we adopt it. I appreciate that in many cases where there is a barger event, one wouldn't be looking necessarily to Section 31. But that's the...
Well, had been able to look to Section 31, Barder wouldn't have reached the House of Lords, presumably.
Yeah. So, it's clear, my lady, my lords, if one were to look more closely at the negotiations that went on in this case, the order that we are now having foisted on Mr. Birch would not have happened, and I can do this perhaps without taking through all the documents, which is just giving you references, if that would be easier, or I could take you to the documents in the negotiations. I'm happy either way. I'll take you to the documents. The husband, Mr. Birch, in his witness statement in these proceedings, it's at page 248, paragraph 17. I've referred you to this before, so I don't expect everyone to read it. It's simply where he explains his thinking as to why he was prepared to do what he did. But it's also clear from the position statement prepared on his behalf for the final hearing, at page 288, paragraph 9. This touches upon an issue about wrongful use of his M&S card, which I don't go into, but 3 lines from the top of paragraph 9, it said on his behalf, W's conduct is a matter that should be taken into account when considering her credibility and genuine intentions in relation to various matters, not least her intention to return to work and to use her best endeavours to release me from the mortgage within a reasonable time, or release H from the mortgage within a reasonable time. As for Mrs. Birch's witness statement, which is at MS 207, paragraph 6, after the FDR, she said, in January 2010, my solicitors advised me that I should agree to the sale of the property when my son Tom had finished his primary education. I was also told there was no prospects of a joint life maintenance order. I felt very uneasy about this, and my instructions continued to be that I did not want the property to be sold until the children reached or nearly reached their majority. At the trial, my position was to be that the property should be transferred into my sole name and for my ex-husband to be released from the mortgage by Tom's 18th birthday. So that was the position she had at the outset. It's clear from a consideration of the attendance note that the judge's view was that this property had to be sold. It's clear that there was some toing and froing with the wife initially wanting to hold on to the longer term, and being advised that she would lose on that, and then being told by the judge that it was likely to be sold. There were discussions going backwards and forwards about whether or not the husband should be allowed a measure, either of 20% or a third after if there was a 2-year deferral. And eventually, a 2-year delay was agreed on those undertakings. So that was after a very long day's negotiation, and it was on the basis that Mr. Birch would be released from his undertaking and would then be able to get on with his life. So
He'd be released from the mortgage.
Yes.
He'd be able to get on with his life.
I want to talk about executory orders. The executory orders in this case...
Well, I don't know. It's up to my colleagues, obviously. Certainly, Mr. Hockman argued that at the time of the application for release, the order was still executory. The order was that your client be released on no later than 30 September. If Mr. Hockman was saying that an application on 29 September would be treated very differently from an application on 1 October, then my internal thinking was that that couldn't be right. And so how much time you feel you need to have to spend on his executory point would be a matter for your judgment.
Thank you very much, my lord. I will be as brief as I can. Just if I
The
could...
rest of us are hugely interested in it.
Well, in that case, I'll take
Not
longer.
all of us.
There's just one letter in the bundle I'd like to refer you to. It's one of the letters that was added. Well, in fact, there are 3 letters that were, well, in fairness, 4 letters were added because the first one was added at the request of the appellants. It's page 353.
Which date?
I think I've got this right. Sorry, it's 352 and it's the 24th of May. This is for the sake of completeness. From my client's then solicitors to the wife's solicitors, where in the second paragraph he says, I will not be implementing the transfer of the former matrimonial home until your client has fully complied herself with the terms of the consent order. So that's 24th of May. And then he sets out the ways in which she hasn't complied. Then it goes silent. And then on the 19th of June 2012, Alfred Truman write, saying, we've noticed that your predecessors did not arrange for the transfer of the matrimonial home into your client's sole name pursuant to the consent order of the 28th of July 2010, and we'd be grateful if you could now deal with this and confirm. So we're asking them to help us transfer the property to them. That's the 19th of June. On the 12th of July, we write again, final paragraph. Furthermore, we've not heard from you in response to our letter of the 19th when we informed you that the matrimonial home has not been transferred into your client's sole name pursuant to the terms of the original order. Please, your immediate response would be appreciated. And then the reply comes back, and it's the third paragraph on the 24th of July, turning now to the issue of the transfer of the former matrimonial home. In light of the fact that we are in proceedings relating to the home, it does not seem sensible to us to wait. It does seem sensible to us to wait to see the outcome of the proceedings before effecting any transfer. So the husband and his solicitors were anxious to get on with it, and the position so far as Mrs. Birch was concerned was that she wasn't. So if one looked...
Mr. Wilson, I'm not at all... I know what the agreement was, that there be a transfer subject to the mortgage. My experience of these matters is that the Cheltenham and Gloucester might well not have agreed to the transfer into the wife's sole name if there was going to be no change to the mortgage. And you say that yourself in paragraph 24. And so it seems to me nothing much turns on the fact that there has been no transfer into her sole name subject to the mortgage.
It remains executory, and it may be that not many points can be made either way on that. But if I could turn simply, if I may, to Thwaite again, please, and to a passage towards the end of it. And again, the court will be familiar with the facts in this case. Final page, beginning with the, I suppose, third paragraph, the dismissal of the husband's appeal.
Could I have the page reference, please?
I beg your pardon, 757, I apologise. Maybe you want to read it. So my Lord, you see that the Lord Justice Ormerod was essentially saying that the claims remain open on either side. Where that takes us, I'm not sure, but your Lordship was saying at one point that if this matter did go back down to be heard again, on my reading of that, and it's a reading that is borne out by considering Bezliansky, the court would be open to make fresh orders, and indeed make orders in favour of Mr. Birch, if my reading of the Thwaite is correct. Bear in mind, in Thwaite, it was a case where the court, or the husband was ordered to transfer the whole property to the wife on a particular basis. In that case, the basis was that she was going to live in England. She moved back, never did live in England, and the court, the judge, perhaps for reasons that were not quite consonant with what Ormerod thought was the logic behind it, came to the conclusion that he could rewrite the order. It's a point I raise simply for the consideration of the court, because it does raise interesting questions. And perhaps some people people I know who are more learned in the law than I, would wonder whether or not Bezliansky was right in making such wholesale changes to a final consent order. But if it is right, and it relies on Thwaite, then it does seem that in certain circumstances one can rewrite the order to do justice subsequently.
The basis of it seems to have been, I'd forgotten about Thwaite in detail, I'm bound to say, Mr. Wilson, my fault, but the basis of it seems to be that the premise of the order had been, in effect, the wife's promise that she was going to live with the children in England.
Yes.
And they don't, the finding is not simply that she subsequently changed her mind, but that she never really had that settled intention. That appears in the 4th paragraph on 757.
Yes. Yes.
In which case, is it at least approaching the kind of fraud stroke mistake case?
Which is Bezliansky.
Which is certainly Bezliansky, and which is catalogued by Sir James Mumby in L&L.
Yes. But I mean, it seems that the principle...
In other words, is it really essential that it was still executory?
The principle seems to remain the same.
It's certainly what Lord Justice Ormerod said.
I want to deal with some, unless your lordships don't wish to hear it, I thought I'd try and deal with what Lord Justice McComb said about the section 31F. And I want to take this moderately quickly, if I may. Page MS number 110, we deal with the fact that Lord Justice McComb touched upon this, and we set out what was said in CS and ACS and in Tibbles and in Sharland by my Lady Hale, and at page 113 I set out what the Tibbles criteria are. There's 44, if a party wishes to contend that it's not appropriate to make the order, that should be by way of appeal, or exceptionally by asking the court which imposed, this is the Master of the Rolls reading from the Mitchell case, circumstances which the latter direct discretion can be exercised were considered by this court in Tibbles. The court held that considerations of finality, the undesirability of allowing litigants to have two bites of the cherry, and the need to avoid undermining the concept of appeal all required a principle called curtailment of an otherwise open discretion. The discretion might appropriately be exercised only, one, where there has been a material change of circumstances since the order was made, two, where the facts on which the original decision was made had been misstated, and three, where there had been a manifest mistake on the part of the judge in formulating the order. Moreover, as the court emphasised, the application must have been made promptly. The one thing we missed out when we were dealing with these cases was some important passages in the case of Norman, which I would like briefly to take you to. It's in volume 2. And it was a case where a woman was consistently going back to court and verging on vexatious. And if one turns to page 711, the Lady Justice King sets out the position in relation to Family Proceedings Rule 4.16, which is in the same terms as the Civil Procedure Rule, and goes through some of the authorities. I want to take you to paragraph 48. For completeness, it should be noted that in his judgment in CS v ACS, the President expressed the view that the practice direction 30A, paragraph 14.1, headed appeals against consent orders, which was then provided that an appeal is the only way in which a consent order can be challenged, is wrong as ultra vires. The family procedure rules have now been amended, and as of the 3rd of October 2016, there is a new rule, 9.9a, supplemented by a new paragraph 13 to PD 9a, and a new paragraph 41b to PD 38 appeals. The correct procedure where it is sought to set aside a financial remedy order, whether made by consent or otherwise, and where no error of law is alleged, is now to make an application to set aside within the proceedings to the same level of judge as made the original order. The new paragraph 4.1b to PD 38 details the level of circumstances. As the new FPR 9.9a provides specifically for the power of the court to set aside a financial remedy order as opposed to any other type of order, then it rather than FPR 4.16, should, as of the 3rd of October, be invoked where such relief is sought. FPR 4.16 will continue to rule any other applications to set aside, which are governed by the family procedure rules. And so, basically, the long-awaited amendment that Lord Justice Mumby, the President, I beg your pardon, wanted, has now been made. It's in the first volume of authorities. I don't take you to it, but what is equally clear is that the Tibble's criteria still apply. If one looks at page 713 and conclusions, paragraph 56, the Tibble's criteria sits snugly with the Supreme Court's approach in recent decisions in relation to application to set aside consent orders in matrimonial finance cases, and in particular in Sharland. So, in other words, the view of Lady Justice King is that FPR 9.9a may apply, but the Tibble's criteria still apply to the exercising of the jurisdiction.
But the principles have not been altered, it's just the procedure has been clarified, which was something that we were talking about in both Sharland and I think in Gobet as well.
But this whole business of Rule 4.16, correct me if I'm wrong, Mr. Wilson, hadn't been referred to before the district judge, hadn't been referred to before the circuit judge, wasn't referred to in written argument in the Court of Appeal, wasn't referred to in oral argument in the Court of Appeal, and Lord Justice McComb spends 43 referring to it and saying it's irrelevant.
Yes,
so, is it relevant?
My Lord, the only relevance it may have is if your Lordship, your Ladyship, think that the Tibble's criteria have any input into what the right test should be. That's the only relevance of it. My final point...
I mean, your point seems to be the one you make at paragraph 49, is that we don't want to be left with 4 different tests, which
Yes.
are basically doing the same thing, which I hope we can achieve.
Yes, this case has been going on so long that I think it started it started before the new family procedure rules came into force. My Lords, my
Nothing
Lady,
wrong with having different tests for different situations.
That's probably right.
The question is to relate try and discover the proper test for the particular situation
Yes,
with
I
which
think
one's
that's right.
confronted.
It'll be apparent from the submissions on both sides that we've been referring to cases that cover a wide range of different situations. And it may well be that there should be different tests for those different situations. What we would say, before leaving this topic, is that when one's looking at situations such as the present, and probably in all situations, there ought to be some sort of threshold test. If there is no threshold, as my learned friend would have it, if a thing is significant because it is significant, then you do get a judicial free-for-all, and the argument ultimately is circular. If something is significant because it's significant, that gives no guidance to the courts below, and the spectre of a situation where there is no threshold requirement would be a bad thing. For example, if there was no threshold requirement, then the next place this would go, depending on the outcome, would be back down to the beginning again, which would not be a good thing. The final point I make is the final point we made in our written submissions, that there is a public interest in finality of litigation. This case has been going on for many years now, and there are many quotes I could take you to, but I will just recite from them. Obviously, in Edgar and Edgar, way back when, the general rule was that courts will uphold agreements freely entered into at arm's length. Lord Hailsham and Jenkins and Livesey said consent orders, where there have been relevant disclosure, are much to be encouraged, and properly negotiate, greatly reduce the pain and trauma of divorce, and they're not likely to be overthrown. And in L&L, Mr. Justice Mumby talked of Mr. Timothy Scott's QC's submissions that Mr. Scott's starting point, with which I entirely agree, is that it is a fundamental principle of public policy, applicable as much in the context of ancillary relief as in any other context, that there should be finality in litigation, a principle which, as he rightly says, applies with particular force where an order has been made by consent. There is, as he says, a strong public interest in parties reaching agreement in cases such as this, for an agreed order will save time, costs and stress for the parties and will reduce the burden on the court's resources, which unhappily are both limited and at present desperately overstretched. An order, he says, should be disturbed only for good and clear reason. I agree. And that was at paragraph 92, tab 16 of L&L. Those are my submissions, my lady.
Thank you very much indeed, Mr. Wilson. I don't think there are any further questions. Mr. Infield?
No, thank you.
Mr. Hotman.
My Lords, I think I have 6 matters that I would like to refer to by way of reply, please. My starting point is to submit that the situation that we have here, in which we are submitting that the wife should be released from her undertaking on condition that it's replaced by another one, should be treated as being equivalent in terms of reasoning and result to a situation in which that which she originally undertook to do was something that she had been ordered to do. In other words, the order stroke undertaking equivalence rule, if I can call it that. And your Lordships are well aware of the point, and I don't think I need to develop it, other than perhaps to remind you of the passage that I referred to quite quickly this morning in L, in volume 2, at page 593, MS page 593 in volume 2, in which Mr. Justice Mundry, as he then was, pointed out that, at paragraph 113, that section 31 entitles the husband to apply for an order under that section, an entitlement not in any way affected by the fact that the order was a consent order or by the fact that the relevant provisions are contained in undertakings rather than the curial part of the order. So I can cite that passage in L in support of our proposition. Second point, therefore, the only class of obligation, to use a compendious word, the only class of obligation which is removed into a separate category is the class of obligation to which by statute section 31 doesn't apply. That means, in effect, and I'm oversimplifying, the class of obligation in which there has been a transfer of property, a property adjustment order. In all other cases where section 31 does apply, then there is no reason to disapply it, and section 31 applies with full effect. So it certainly applies in the case of a section 24A order for sale or an undertaking to that effect. And I can cite in support of that proposition a case called Omielan, which I think I'm right in saying, I'll certainly be corrected if I'm wrong, counsel for the husband here did not take you to in the course of his response. It's a remarkable fact in this case that despite that case being relied on as the platform for a preliminary objection to our argument, and I'll show you the reference to that, no reference was made, at least you weren't taken to Omielan by the husband in his submissions. But Omielan in our submission, for the reasons which I explained in my opening remarks and which I don't seek to repeat, supports this proposition. Omielan shows, if you look at the judgment of Lord Justice Thorpe, that it was the fact that the proposed variation was a variation to the property adjustment that made it impossible to grant that variation application. And that is what is meant by revisiting the territory of the primary order. Revisiting the territory of the primary order doesn't mean revisiting any part of a consent order which people happen to think is important. All parts of a consent order may be important, but revisiting the territory of the primary order is revisiting the property transfer element. That's what it means. See Omielan. Those are the propositions for which Omielan is authority and which we invite this court to approve. I only need to add a word in this context in relation to the case of Birch, which was cited by my learned friend and which I didn't mention. Birch is at tab 14 in volume 1, starting at MS page 532. And you can see that the issue playing out in Birch at page 541 MS page 541, page 171 in the report. In which Lord Oliver of Aylmerton analyses the nature of the property adjustment which is involved in a very similar way to the analysis in Omielan, in a comparable sort of analysis, about halfway down the page. He says, it was against this background that the consent order was made. It had a number of significant effects upon the husband's interest. First and foremost, it imposed on the husband's right to call for an immediate sale a fetter preventing him from realising his entitlement until the occurrence of one or other of the events specified in the order. Secondly, and against the background of an injunction excluding him from actual possession, an order for the ultimate division of the net proceeds in equal sales without any provision for an account being taken of the value of any rents and profits in the meantime, had the effect of reducing the husband's beneficial entitlement, whilst at the same time the order sought to impose on him an obligation to continue his contributions to the reduction of the capital outstanding under the mortgage. I cannot therefore agree with the view that the order made no adjustment of the rights of the parties as they previously existed in law and equity. So here again, the territory which is immune under the Omielan criteria is territory in which the rights of the parties are changed. That can't be changed. That can't be reviewed. But there would be, but just to conclude this second point, there would obviously be, it would be pointless to use the phrase revisiting the primary territory of the order as creating an immunity for the entirety of a consent order. If that were the law, then none of the cases that we've been looking at would ever have arisen. They'd all be ruled out of court. Now, my third point, coming to the order that we have here, is simply to repeat what I said in my opening, which is that this order does not revisit or invade inadmissible territory. I don't repeat what I said this morning. I simply remind your lordships respectfully that when my Lord Wilson raised the point with Mr. Wilson in argument, raising it by reference to the judgment of Lord Justice McComb and asking where Lord Justice McComb identifies the element of property adjustment which is allegedly revisited by our application, my learned friend admitted that Lord Justice McComb never does that. It is an omission in the judgment, and that omission is not due to, with respect to the learned Lord Justice, to any carelessness on his part, plainly not. It is because there is no such possibility. The order, he couldn't have answered that question had it been put to him, that the order does not involve amending the property adjustment. That's the whole point. And Mr. Wilson, in argument, was unable to suggest that it does. Now, if I'm right so far, then in a nutshell, this is a Section 31 case. The interests of the children are paramount, and with respect, that
Not
means
paramount.
Not paramount,
primary. And with respect, we would say there is in that case only one answer. We would say that in those circumstances, your lordships ought to allow the appeal and confirm on the basis of the revised undertaking which we put forward, which is simply to extend the period until Tom reaches the age of 18.
So you're now suggesting that we should allow the appeal and bring about a revised undertaking,
Yes,
rather than remit it to a district court?
It's always been my primary contention that your ladyship and your lordship should do that. Yes. Now, let me go on to my fourth point, if I may. My fourth point concerns the question of significant change, because the general thrust of the argument against us is that if I have a case at all, it has to be based on significant change, and there has here been no significant change. I attempted to advance five general propositions, which I hope would be of some assistance in relation to that, and I'm not going to repeat those. I know your lordships have them, and in particular I said, for example, that the word significant doesn't add anything to that which is involved in the justice of the case, but I'm conscious of the authorities which are not altogether consistent with that, none of them binding on this court, of course. Let me go on as an alternative point. I'm not sure if I quite put it in this way expressly previously, but what I would certainly want to argue is that if I have to show a significant change, then I have shown one. And in a nutshell, the way I would argue this is that whether a change is significant depends upon the context. That it depends upon the aspect of the order to which the change relates. The only aspect of the order which we're dealing with here is an order relating to the period before sale. And it is precisely in relation to the period before sale that the change in circumstance relates. It is the fact that the wife was unable to fulfill her undertaking within the time available, unable to arrange the transfer. As my Lord Wilson rightly said, I'm paraphrasing what your lordship said, the order imposed on her quite a burden. The order imposed on her the task of achieving something which must have been rather difficult, namely achieving the transfer of the liability under the mortgage from joint to one which was applying to her alone. So that there was in our submission, clearly, in relation to the relevant circumstances, a significant change by 2012, and that justifies the extension of time which effectively we are seeking.
Well, Mr. Hawkman, the problem is that this has never been gone into, because a preliminary issue was appointed on jurisdiction. All of these questions about significant change.
Yes.
Could your client reasonably expect the sister and the brother to guarantee? There's no statement from them. You would say there's no statement from them because nobody's got onto the merits. But at all events, nobody's got onto the merits.
Yes.
Nobody's looked at all these considerations. That's the difficulty.
It is a difficulty. Lord, just on that point, and this was going to be my fifth submission in reply, if your lordships would go in the core volume to MS page 191. In fact, it starts at MS page 190, page 71 in the appendix. This is a skeleton argument prepared on behalf of the respondent husband for what I think was the substantive hearing before the district judge. And you will see that it is indeed in this skeleton argument that the preliminary issue is raised.
Have we got any of the case management orders there were in this case? Because there does appear to be a dispute between you as to how this came about.
Well, what there can't be any dispute about, my lady, with respect, is that this was a preliminary issue raised on behalf of the husband. Here it is on page 191.
Paragraph 10. It does look rather like that, Mr.
Yes.
Hockman.
Yes. Now, it was raised in that form. I'm not being critical of anybody. I'm certainly not being critical of counsel who pleaded this. I'm not being critical of the district judge for deciding to take it as a preliminary issue. This point is as much a shield as a sword, I think, because what I'm doing is resisting any suggestion that the lapse of time should detract in some way from the case I'm putting forward on Section 31 on the one hand, or on significant change of circumstances on the other.
All we know there's something in the statement of facts and issues about this. How far it takes us, I'm not sure. 38. Originally listed for final hearing on the 11th of January 2013.
Yes.
But it had been listed in 2012.
Yes.
Yes, quite.
Yes.
Initially, 15th of August 2012,
Yes.
which was Tom's birthday. The skeleton which you've just taken us
Yes.
to was for the
Was
30th.
for that hearing, yes.
Yeah. An earlier one.
I know there were listing difficulties in the case at various stages, which is why it's taken so long. Or one of the reasons why it's taken so long. But clearly, it was the preliminary issue was one raised on behalf of the husband. It was raised as a preliminary issue, and the court may well have obviously did agree to deal with it as a preliminary issue, and. As I say, I'm not being critical, but all I'm saying is that perhaps I can say two things now. I mean, what I can say now, I hope, without fear of contradiction, because my argument on this wasn't challenged, is that on any view, the preliminary issue based on Omi Elan was a non-starter. Nobody now suggests that Omi Elan, which was the basis of it on page 191, was a valid basis on which a preliminary issue could be raised. So whatever the basis is, which we respectfully find still rather unclear, it certainly can't be the Omi Elan basis. But if it was thought bona fide that there was some preliminary issue to be raised, well, so be it. No doubt it was a sensible thing to try and deal with it in that way. But all I'm saying is this court, with the utmost respect, would not wish, we submit, to penalise us or to treat it as an argument against us that time has elapsed. We're entitled to say, well, it's taken this long for us to get here and to find that Omi Elan, in fact, is entirely supportive of our position, not supportive of the position on the other side. My sixth and final observation merely relates to, as it were, the relative positions of the parties and of the children. Of course, I wholly agree with my Lord Wilson that it must place this court in a difficult, if not impossible position. In fact, in an impossible position, if what this court has to do is to evaluate the rival contentions based on a property valuation which is not agreed and where there's quite a difference, and so on. I hope that this court will bear in mind, and I respectfully submit it should bear in mind, the comments I made earlier about the disadvantages, the disadvantageous position in which the wife finds herself. Let it be admitted that continuing to be obligated under this mortgage is, at least in theory, a disadvantage for the husband. I didn't dispute that in my opening, and I don't dispute it now. What I say is it's not a disadvantage in practice for that to happen for another 2 years, because we can safely rely on the wife continuing to pay the mortgage. She's never defaulted, even when she didn't have a job, and now she has got a job. And she wants the children to stay in that house. So she has absolutely no reason to default. So in practical terms, it's not a disadvantage, other than the suggestion that he can't as readily go out and buy a property himself as he might otherwise wish to do, although I did make the point this morning that he must have been able to build up some capital, or at least he could have done if he'd wanted to. But all of this, we respectfully submit, if there ever were a rehearing, would have to, or another hearing, would have to be set in the context of the fundamental disparity in their financial positions, his ability to start again and her.
Well, you've said all that, Mr.
Yes.
Hoffman, and you are over your time, so
I'm
I'm
very
not sure
sorry,
you're
I-
doing your case any good by continuing.
In which case I won't continue, save to conclude by saying that even in this much more grey area, even if it's a case of judging the facts, surely the interests of the children would continue to be extremely important. And we respectfully submit that on that point, this court might well conclude, in any event, that the deferral that the wife seeks is entirely justified.
May I just raise one correction, my lord? Your lordship said the evidence on the merits wasn't in. The wife's evidence on the merits was in. It was the statement at MS 205. The evidence on the merits was in prior to the decision being taken.
I mean, we've read the statement of the wife and the husband, but I was, for example, pointing out there's nothing, as one would expect there to be something, from the brother and the sister.
No.
And there isn't.
No. But that was the evidence that was...
And had there not been a preliminary issue, they might have been added into it.
Yes,
But I mean, irrespective of evidence, there's been no investigation of the merits.
that I accept, my lord, but simply the evidence had been put in, such as it was.
Thanks.
Well, we are very grateful to everybody for their submissions, both orally and in writing. We are particularly grateful that people have been willing to act pro bono in this case. We always appreciate that because if a case comes here, it is because it involves a point of considerable public importance, and we need all the assistance we can get. So we're very grateful. We will now go away and try and puzzle out an answer. Court is now adjourned.